The Jack Spring Electric Keel Newsmaker Hotline. Joining us for a little bit is Mr. Jimmy Faircloth. He is a lawyer from Alexandria. Mr. Jimmy, thank you for taking time for us. Welcome to Keel. How are you doing today?
Good morning. Thanks for having me.
Okay, so you are the legal representation for 11 Louisiana bar owners. You have filed a lawsuit. I will stop there and let you pick it up. Take the story from this point.
Well, it's actually more than that. There's also like 20 plaintiffs that we represent in a companion suit that's been filed yesterday afternoon in the Eastern District. But to kind of give you the overview, there are 11 bar owners in the Acadiana area, which is within the Western District of the federal court system in Louisiana. And so those 11 bar owners have filed suit, and then there's a companion suit, which is basically identical in its allegations, filed on behalf of approximately 20 bar owners in the Houma, Morgan City, and moving over toward New Orleans area, which is the Eastern District of the Louisiana federal court system. So the suit, in a nutshell, alleges that the bar closure restrictions are not sufficiently tailored, and that they're overly burdensome, and frankly that there's no science to support any distinction between bars or any other establishments with regard to the transmission of COVID. Now that's the base of the lawsuit.
You had
deprivation of fundamental rights by doing that.
You had made the point, I think, earlier on, or you had said, if this mandate had come from the governor's office earlier on, at least you could have kind of maybe understood. But now you think it's is beyond the pale, too strong a word.
Yeah, no, I'll go a little further than that. We take no issue with his initial issuance of the order, and we pled that specifically. I mean, it was early, very little science existed, and I think deference did have to be given, and I think the law supports that. But now we're 5.5 months into this, and there's a great deal of science and trace information and data that's available to make informed decisions. So it's a very different time now.
The governor says, and I'm quoting here, Governor Edwards is confident the action he has taken to close bars to on-premise consumption is both legal and necessary to protect the health and safety of the people of Louisiana, and the White House agrees with the governor. Your response to that comment that came from the governor?
Well, my response would be the White House does not dictate to any state how they respond. As a matter of fact, of the 50 states, I think 30 do not close bars. And I think of the 20 that do have some form of closure, it's very different. Some states have, if you sell any food, you can sell $10 worth of food and keep your bar open. So if there's any food sales at all in the bar, it stays open. There's just a big diversion in terms of the states how they treat this, because it is an issue for the states to decide. So I think it's a bit of a dodge for Governor Edwards to say, I'm going to let the White House tell me how to do this, because the White House has not said you have to have a categorical. That is just simply not the case.
Okay, you were the executive counsel to former Governor Bobby Jindal. If you were executive counsel to the governor in the middle of this crisis, what would you have told him to do? If they say they can trace 400 plus cases to bars, what would you tell the governor he should do?
Well, I would tell him to rely on the health experts and the DHH data, or LDH data. And if there's no differential treatment or no differential result looking at the data, then you can't differentiate. It's really a question of equal protection. And right now he has an order in place that essentially is based on the assumption that bar owners account for a disproportionately high source of transmission of COVID. And that is not the case. There is no science whatsoever to support that. And in fact, the LDH data says the opposite. It says that only 0.5% of all known COVID cases may have come from bars. And so our position, we haven't retained an expert to come in and offer cooked up science. The LDH data itself, the governor's data, doesn't nearly support this type of restriction. And so at this point, we feel like the burden's on him to come forward and demonstrate some rational basis for this decision, because right now he hasn't done so. It's not in the proclamation. It's not in the LDH data. And the closest he's come to explaining it is in news conferences where he said, well, the White House tells me to do it, and he believes that young people, I assume, will act irresponsibly with alcohol. That's really about as far as it goes in terms of rational basis.
So
that is not sufficient.
What's your time frame? Walk us through the process here and what you hope to see happen.
Well, we've requested a temporary restraining order from the judge in the Western District, and that is under advisement now. I expect the judge will rule on that very quickly. I think he will also, I know he will also set a hearing for next week, and there will be a hearing on an injunction, on a preliminary injunction. So we'll have an opportunity to go to court and hear what the governor's explanation is and to challenge the evidence.
Yeah, I was just going to say, I wanted to back up a little bit a second, and if you could give us a little bit of detail about how that hearing will actually work. I would assume you're going to present many of the same points that you just presented here in our conversation. And what case do you make before that judge?
Well, our case will be that the law is very clear that governors do have extraordinary discretion in times of emergency. But the law is equally clear that there has to be a real and substantial relationship between the restriction and the stated government goal. That real and substantial relationship doesn't exist here. I mean, that's the phrase that the Supreme Court uses, the real and substantial relationship. What we have here is supposition about how people may act. Now, it may have started off legitimately because there's an assumption, people stand closely in bars and they may not wear a mask, but the process has matured enough now to where scientific decisions can be made. And the burden's on the governor. He lacks authority to simply tell people you can't conduct your business. He lacks that authority absent extraordinary circumstances. And here, that doesn't exist.
Shreveport-Bossier bars that may want to be involved in the lawsuit, can they become involved? Do they need to get in touch with you? If they have concerns and want to be a part, what do they do?
Well, and I don't want to solicit business, but the lawsuit, it's important that the lawsuit is narrowly tailored for relief for these plaintiffs. So the lawsuit asks the judge to enjoin the enforcement of the orders as to these plaintiffs. Now, to make that decision, the judge will have to review the constitutionality he believes of the basis for issuing the order in the first place. So I think this judge's ruling on the declaration will go a long ways to causing other people to act and other judges to perhaps follow. But the order itself seeks a very narrow relief that will only grant relief as to these folks. So if I would encourage anybody that's interested to either contact us or contact some other counsel or file your own lawsuit or wait and see how what happens, and maybe something will come out of it good and the governor will stand down or pivot to something more tailored.
Could this nullify the order to close the bars? I mean, could this nullify the statewide order and then local bars here in Shreveport-Bossier wouldn't have to take any action?
No, it won't nullify. That's the point. It will not nullify the order statewide as to non-party bars. But I do think the governor will respect the order. It will be an order from a federal judge saying that there's no basis for this. You can't do it. So I think it will have an impact. There's no question about that.